and thank you for joining our webinar today on the importance of incapacity documents and incapacity planning. The goal of my webinar today is really just to provide you some basic information about, one, what do we actually mean when we say incapacity planning documents? What are those documents? And also to discuss some common questions concerning incapacity documents or common issues that can arise. So from a very basic standpoint, what are the purpose of incapacity planning documents? Well, the purpose, as the name implies, is to appoint someone to assist you in managing your affairs should you become incapacitated in some way. So there are two areas where the incapacity planning documents would apply. One in regards to financial matters, and to appoint someone to assist you with financial matters where the document you would use would be a power of attorney. And the second area where you would assist someone to appoint someone to assist you, with handling your affairs is for medical affairs. And for those documents, you would use either the healthcare directive or sometimes referred to as advanced directives. And the purpose would be to appoint a healthcare representative, and may also include a living will, and can also include a HIPAA waiver. So to circle back to financial matters, again, the incapacity planning document you would use would be a power of attorney, and you would appoint an agent to assist you with any and all types of financial matters that if for some reason you're unable to handle your financial affairs yourself, the person you've appointed in the power of attorney will have the legal authority to essentially step into your shoes and become you for financial decision-making purposes. So if you need someone to help you sign checks, someone to go down to the bank and help manage your accounts, file your tax returns, register your car with the DMV, really anything and everything concerning your assets, the person you've appointed under your power of attorney is going to be able to assist you with those items. However, because they get to essentially, whomever you've appointed gets to become you, it goes without saying you should be appointing someone you trust implicitly, because I have heard the power of attorney referred to before as a license to steal, because you really are giving somebody carte blanche, complete access and control and management over your assets. So 90% of the time, the people I'm working with are appointing a spouse, a child, a family member, someone they do trust. But again, it gives, you should have pause when considering who to appoint as that financial decision maker for you, just again, because of the control and access that they're going to have over your assets. One common misconception about powers of attorney is, as the name implies and as the seminar is called, a power of attorney is an incapacity planning document. And that's the intent. The power of attorney is only supposed to be used when you're incapacitated. However, our standard power of attorney is able to be used by your agent even if you're not incapacitated. So, for example, our standard power of attorney language says the person who you've named in the document has the authority to do all those actions that I mentioned before, signing checks, paying bills, all those types of things, regardless of whether you're incapacitated or not. As long as they show up, your agent shows up to the bank with a copy of the power of attorney in their hand, they're going to be able to do what needs to be done. The reason why this makes sense, even though I know it sounds really like an unchecked power and authority you're granting to someone else, is that there may be situations when you're not incapacitated that you may still need assistance in performing certain actions. To give a hypothetical, one that it's not so much of a hypothetical because I have seen it before, is a husband and wife are buying a house prior to the COVID-19 crisis, and the husband had to be out of town for business at the time the closing on the house was scheduled. So in order to allow his wife to sign on his behalf all the different closing documents, the husband granted the wife power of attorney. So she had legal authority to sign on his behalf, even though he wasn't incapacitated. So sometimes power of attorneys, again, using the power of attorney still makes sense prior to your incapacitation. But if that type of, again, access to your assets or handing over that much authority gives kind of a little pause, makes you a little uneasy, there is another type of power of attorney that's called a springing power of attorney, which only does become effective when you actually are incapacitated. So it's very similar to what I call the standard power of attorney, where it lists out all the authority you say you want your agent to be able to have, and it's all the same authority. However, it says, but I have to be actually incapacitated in order for my agent to act on my behalf. So in addition to showing up at the bank with the power of attorney in hand, your agent will also need some written confirmation from your physician that you are actually incapacitated. So it's still, again, going to allow the person you've appointed to have that authority, but only when you actually are incapacitated in some way and unable to manage your own financial affairs. So that's the power of attorney side of things. The second set of documents, again, that I referred to is for medical decisions, the primary document being the healthcare directive, or again, as I mentioned, it's also sometimes called advanced directives. But the primary purpose of the healthcare directive is to appoint a healthcare representative. So just like your agent under your power of attorney could make all your financial decisions for you, your healthcare representative under the healthcare directive is going to be able to assist you in making any type of medical decisions. So the big difference between the healthcare directive appointment of the healthcare representative and the appointment of the agent under the power of attorney is, as I just explained, with the power of attorney, your agent can potentially act for you immediately, regardless of whether or not you're actually incapacitated. With the healthcare directive, your healthcare representative is only going to be able to act for you and make decisions on your behalf if you are incapacitated. So long as you're aware of your surroundings and you can communicate your wishes to your doctors are going to take direction from you. It is only when you're unable to communicate those wishes to your doctors that your healthcare representative is going to step in and start making those decisions on your behalf. Also, another component of the healthcare directive is the living will. And despite the name, living will is very different from your last will and testament, even though they're both estate planning documents. They both do vastly different things. So the last will and testament, which Attorney Dakin had gone over in the seminar about 2 weeks ago, where he discussed kind of estate planning 101, the last will and testament directs where your assets are going to go upon your passing. The living will recites your wishes in terms of receipt or withholding of medical treatment at end of life. So, for example, our standard living will language provides that should you be terminally ill, permanently unconscious, really end of life, that you do not wish extraordinary measures to be taken to save your life. So no artificial means of hydration or nutrition, no feeding tubes, no artificial means of ventilation, no ventilators, no CPR, all those types of things. However, again, I do want to emphasize this point and be very clear, the living will only applies at end of life. I have a lot of clients who are very wary about having living wills prepared just because they think a doctor is going to see that they have a living will and kind of say, I'm not going to bother trying to save this person. I'm not going to give them the medical treatment they need. And that's not really how it works. So you can rest assured your doctors and the EMTs are always going to do whatever they can to save you because that's their job. However, if they're aware that you have the living will, again, the living will is only going to apply if you have a terminal condition or are permanently unconscious. If it's a condition you're expected to recover from, the living will isn't going to apply. So for example, if you were in a car accident and you're in a coma for a few days, but then the doctors expect you to wake up and make a recovery, they're not going to be looking at your living will, again, because there is that likelihood of your recovery. Also, particularly in light of the current COVID-19 crisis that's ongoing, living wills, healthcare directives are so immensely important. There's been so many situations of cases where patients coming into the emergency room either with or without family members, but there's no incapacity planning documents. There is no healthcare directive. There is no living will. So doctors and family members are to some degree left scratching their head, wondering what you would have wanted and trying to guess as to the decisions you would have made. So it is so important just to have these documents prepared and have them available to your loved ones or even have made available to your physicians just to avoid any potential issues. So, and I think the last document that I had said, because we've covered the power of attorney for financial decisions we've covered, the healthcare directive, which is going to include the appointment of a healthcare representative and living will. But the next document for healthcare issues is, I had also mentioned at the beginning, is a HIPAA waiver. And HIPAA is all about release of protected medical information. Your doctors aren't just going to release your information to anyone willy-nilly without your consent. And a HIPAA waiver is simply a form that says the people I've listed on this form have the authority to have access to my medical information and are able to speak with my doctors. So that's just another form that is made available. So now that we have kind of a understanding of what the documents are, what they do, I'm going to discuss what I've seen as some of the most common questions that I get on a daily basis, or some issues that I've seen arise with these documents. So the first question that I get a lot is, what is a durable power of attorney? How is it different from a regular power of attorney? And the simple answer is usually it isn't. So when I say power of attorney, that's what I refer to the document as, but it implies durable. The full legal name, I guess, is you would call it a durable power of attorney. The importance of that word durable means that should you become incapacitated in any way, your power of attorney is not revoked. It's still valid. It's still effective. I know that sounds almost silly that you need to clarify that because that's the whole purpose of these documents, is they're supposed to be for your agent's use should you become incapacitated. However, prior to 2016, the law in Connecticut was the opposite. The law said that unless your power of attorney specifically says it is a durable power of attorney, it isn't durable. So it's going to become void upon you becoming incapacitated. I guess the lawmakers finally realized that was not a good rule, and so they reversed it. In 2016, they enacted a whole bunch of legislation regarding powers of attorney, and one of the effects of that legislation is that the default is now that all powers of attorney are durable unless you specifically say it is not durable. So whether your power of attorney says durable at the top, whether it says just statutory form power of attorney, if it has the term durable in there and not, the default rule again in Connecticut is that it is always durable, unless you specifically say in big bold letters, I do not want this to be durable. Keeping with powers of attorney, and actually a question that we had submitted by someone in advance of the webinar today is, what happens if a bank refuses to accept my power of attorney, or what happens if a bank says I have to sign their form of a power of attorney and they won't take mine, they need it on the bank's form paperwork? Well, under that new set of legislation that I mentioned that the Connecticut legislature adopted in 2016, they can't make you do that. So long as your will is validly executed, and if you went to an attorney and had it signed, witnessed, notarized, it's validly executed, a bank can't refuse to accept your power of attorney. It also cannot require that you sign a new form of power of attorney. And this was the reason why the legislation that was enacted in 2016 includes that, is because this is a very big problem we were seeing a lot. Mom or dad signs a power of attorney, appoints child as agent, and then 2 years later, mom and dad become incapacitated. Child goes to the bank and attempts to use the power of attorney, and the bank says, no, you have to use our form. You need mom and dad to sign a new power of attorney. But by that point, mom and dad didn't have the capacity to sign a new form. So it kind of left these accounts locked and untouchable just because the bank was refusing to cooperate. So in light of that, this new legislation says the banks can't do that anymore. They have to accept your power of attorney. Or if they have any doubts as to whether or not they can accept it or whether it's still valid, they do have the right to request a legal opinion. So they can say, provide us with an opinion from your attorney that the power of attorney is still valid. They can do that, but they can't just flat out refuse to accept it. If they do, there are penalties in the law. Now that basically is going to make them could pay fines, court costs if you have to go to court to enforce it. So there are penalties for banks should they fail to recognize a power of attorney. So if you do have any problems with a bank, and unfortunately, even since the enactment of the 2016 laws, we do still run across these issues. A lot of times it comes with the big national chain banks that just don't operate solely in Connecticut. again, we are still seeing this come up, to simply inform the person, and you may not be able to get through to the teller, but you may have to go up to the manager or maybe even to the legal department at the bank and inform them that Connecticut law requires that they do have to accept the power of attorney. And if you're still having issues and if the bank is still stonewalling you, I'd recommend you contact an attorney to make that call for you, and again, inform the bank as to what their legal obligations are. Also, with both powers, another question that I get a lot of times that applies to both powers of attorney and to healthcare representative or healthcare directives is, can I appoint multiple people? And the simple answer is yes. You can appoint one person, or you can appoint 2 people, you can appoint 3 people, you can appoint 10 if you wish. I don't recommend that, just because the more cooks in the kitchen, the more potential for problems. However, you can appoint, the simple answer again is you can appoint more than one person. And when you are appointing more than one person, just be sure that the people you're appointing will be able to work well together. Just because if ultimately they're not able to come to a meeting of the minds, it's going to bring everything to a standstill, and they're not going to be able to do anything on your behalf if they're just worried about fighting each other. I've actually had situations where parents say, well, my kids have never really gotten along, but I'm going to appoint them both as my agents under power of attorney, and that's going to bring them together. That's going to be the moment where they come together for the common good. And it just usually doesn't work out that way. Again, if people don't get along now, it's highly unlikely in a moment of crisis they're going to decide that now they're going to put their differences aside and work together calmly and with a cool head. That usually just doesn't happen. So again, if you are considering appointing multiple agents, just make sure they're able to work well together. Also, when you're appointing multiple agents, you do have the option to either have the agents serve jointly or severally. And the difference between those two terms is if you appoint them to serve jointly, you wish for the agents to do everything together. You want both of them to sign off on all the checks. You want both of them to speak to the doctors and give their approval. You're kind of handcuffing them together, so to speak, and requiring them to act together. Severally is a little bit different because you say you permit your agents to act independently of each other. So if only one of your agents under power of attorney can make it to the bank, one can sign on the behalf of both. If only one of your healthcare representatives can make it to the hospital, they can make the decision on behalf of all your healthcare representatives. So again, they're able to work independently of each other. Another common question, what's the difference between a DNR and a living will? And there is a difference, but the purpose behind the two is relatively similar. So with the DNR, or do not resuscitate, this is a document that can only be prepared by your doctor, so it's not something a lawyer can prepare for you. And it really states that if you die, if your heart stops, you do not want the EMTs, you do not want the doctors to resuscitate you to try to bring you back. The living will, as I kind of mentioned before, is a statement as to what you want in terms of medical treatment or what you don't want for medical treatment at end of life. So you may have a somewhat prolonged period of time before you pass, and in the meantime, you don't want CPR, you don't want feeding tubes, and you don't want ventilators. So they serve similar purposes, but again, are applied in a medical setting in different ways. Let me just see, I think one of the other big questions I wanted to address is something that Attorney Sutton had brought up in his webinar last week, is joint ownership of accounts versus power of attorney access to accounts. And I think Attorney Sutton had mentioned it came up, when he was talking about applicability or eligibility, for the Medicaid process. In the instance I think he had stated that if 2 people are on account, if there's a joint account, the asset is going to be deemed 100% available to both of the joint owners. So if only one of the joint owners is applying to Medicaid, they can't say that it only belongs to the joint owner that's not applying for Medicaid. It is deemed wholly available to the person who's applying, which it becomes an issue in the example where son is on mom's account, but son has put the majority of the money in the account is son's money. If mom then goes to apply for Medicaid, all of that money is going to be deemed, again, available to mom and maybe be required to be spent down in order for her to become ineligible. And the only way to refute that is to have an appeal and talk to DSS and provide evidence as to the source of the funds. And just generally, it's a situation you want to avoid. So sometimes an easier way to go about that, if the main motivation for having the joint owner on the account was to assist with management of the accounts, to help you pay your bills, power of attorney is definitely another way to go about that. So they're still going to have the same level of access as the joint owner does, but it's not going to be deemed owned by that other person. So that's a much simpler and sometimes cleaner way to handle that issue. Also, another concern that I recommend all of my clients consider when they're talking about putting joint owners on accounts, and again, mostly it's parents considering putting children on accounts, is not only to be aware of the concerns, as I mentioned, for Title 19 or Medicaid eligibility, but also to be concerned that just generally joint owners, if you put your son as a joint owner on an account and he then is involved in nefarious business practices, or if he goes off and marries someone and later gets divorced, or goes through a car accident, or goes through an intersection and T-bones somebody and then gets sued. For whatever reason, if that joint owner is hauled into court, he gets sued, he gets a judgment against him, people are trying to come after all of his money now includes your assets. So again, by making that joint owner have access by power of attorney versus making them a joint owner, you're going to avoid having those assets come up on the chopping block for that joint owner's creditors. So there's a level of creditor protection there when you're allowing the access via power of attorney rather than making that person a joint owner. So those were all the main points that I wanted to discuss regarding powers of attorney and healthcare directives. The one last program that we have here in Connecticut that I just wanted to spend just 1 or 2 minutes talking about is the MOLST program. So MOLST is an acronym. It stands for Medical Orders for Life-Sustaining Treatment. And it's very recent. It was just enacted in Connecticut in 2017. And it serves a similar function to the living will in regards to setting forth your wishes as to the type of treatment you either do or do not wish to receive at end of life. However, it's more akin to the DNR in that it's deemed to be actionable medical orders. For example, when your doctor sees you have a living will, he just can't say, okay, they have a living will, I'm not going to put them on the ventilator. Generally, what the doctor then does is goes to your healthcare representative and says, this person has a living will, but do you want us to put him on the ventilator or not? Your healthcare representative is still going to have to make that call. A DNR, or this MOLST form that I'm going to give a little bit more information on, are actionable medical orders. So if the doctor sees those in your chart, he doesn't need to talk to anyone. He doesn't need to ask questions. He already has his directions from you and, again, can act on them immediately should a situation arise. And the difference between the MOLST and the DNR is, again, the MOLST is more akin to the living will in that it has instructions for leading up to death. Here's what I do and do not want. It's much more specific in that it addresses some very specific situations as to if you get an infection, do you still want antibiotics? Or in certain situations, do you want these courses of treatment? It gets much more detailed. And it's also a form that can only be prepared by your doctor. So again, it can't be prepared by an attorney. And it's only available to patients who have a terminal condition. So if you're 50 years old and healthy, your doctor is not going to be talking to you about a MOLST form just because it's not something that's going to be prepared unless you actually have a terminal illness. So I think the big takeaways from all of the information that I provided today is, one, the sooner you plan, the better. I've had clients who have said to me, I'm just going to wait till I get sick, then I'll prepare the documents. And I really advise you not to employ this strategy, just because the last thing you want is me showing up at your hospital bed to try to sign a power of attorney or healthcare directive. Because a lot of times when I've had those situations, I have to unfortunately turn to the family and say, I can't have you sign these documents. You don't have capacity, or you're not able to for whatever reason. So sooner you plan, the better. It's better to have these documents and not need them than to not have the documents and need them in a time of crisis. And also, communication is key. If you have these documents, make sure you provide copies to the people you've appointed. Make sure you provide copies to your doctors. One of the worst things that can happen is in the time of crisis, somebody all of a sudden discovers they're your healthcare representative and they have to start making decisions about your care, and they never knew. They've never talked to you about what you wanted. So talk to your doctors, talk to the people who you've appointed, it's going to be so helpful in the long run if you be proactive and take steps now. So having said all that, I'm going to take a look at some of the questions that have been submitted. So the first question is, can you tell me the specific law I can reference that requires the bank to accept the durable power of attorney, or how I can look that up? I don't recall the exact statute number off the top of my head, but what I can do is I can direct you. You can even Google, it's the Connecticut Uniform Power of Attorney Act. So you can simply say that the statute is in the new Connecticut Uniform Power of Attorney Act. Or alternatively, I can provide you with an email following the webinar today with the actual statutory reference. Okay, the next question is, does the Connecticut Power of Attorney law enacted in 2016 only pertain to accounts established in Connecticut? And how common is this among other states? So Connecticut Uniform Power of Attorney Act, it is the Uniform Power of Attorney Act, so which is a national legal framework. So a lot of states have adopted the Uniform Power of Attorney Act. However, states do have the freedom to kind of modify it to make it specific to their state. So not every state's Uniform Power of Attorney Act is exactly the same. However, if you're a Connecticut resident and the accounts are at a bank that's here in Connecticut, so I'm just going to pick a random national chain. So you have an account at Wells Fargo. If you live in Connecticut, you've been working with a financial advisor in Connecticut, I mean, you should still, there should be no reason why you can't use your Connecticut power of attorney. Also, even if it's, again, it's a national chain and you've been dealing with advisors out of state, again, so a lot of states have what they call reciprocity, where they recognize if your document was valid in the state you signed it, it is also valid in the state that they are in. So again, there should still be no issues if you're crossing state lines. Another question, are you available for in-person consultations? Are we open? Yes, we are open. We are trying to some degree, limit the amount of people we see in person. So we are doing a lot of Zoom meetings. We're doing a lot of phone conferences. But ultimately, for documents such as powers of attorney and healthcare directives and wills and such, we do need to meet with you in person to sign. So we are holding in-person meetings. We are, even for people who want to come speak with us, but are maybe even a little bit reluctant still in light of current health concerns, to maybe come into our office. We are meeting people at their cars, sliding paperwork through the window and having them sign and pass it back out. So we do also have a lot of information as to our protocols available on our website in terms of the different ways that you can meet with us and contact us. So please feel free to look at our website for that information as well. So those are all the questions that I see. I'll probably wait another minute here just to see if any questions pop up. And maybe just to fill the time, there's one point I think I kind of touched on a little bit there in one of the questions that have been asked. If you are crossing state lines, if you are either from another state and moving to Connecticut, or you had documents prepared in another state and subsequently moved here, or you had documents prepared here and moved to another state, we also do always recommend you have your documents reviewed by an attorney in the state that you're in, just to make sure there's no, again, state-specific requirements that are supposed to be in the document that may not be. So for example, if you had a Connecticut power of attorney, you moved to Florida, you just want to make sure that your documents are in compliance with Florida law. So we do always recommend you have those documents reviewed. And as a general rule of thumb, we also say you should also take a look at your documents every few years anyways, just because life changes, things happen. So just to double check to make sure the people whom you've appointed are still the people you want serving in those roles. So I don't see any other questions coming in. So thank you all for attending the webinar today. Thank you for attending this the whole series if you've participated in the last few webinar sessions. We do hope to have some upcoming webinars on different topics. If you do have any suggestions for topics that you'd like to see us present on, either in estate planning and elder law or otherwise, please submit them to us through our website. Otherwise, again, thank you very much for coming today.